we finished report backs. We're also going to talk a little bit about attendance, though, and what we do when we're in this situation.
Do you want to have people introduce themselves?
Yeah, I think it would be helpful. So first, let me introduce Clara. She's one of our graduate law clerks interns. She's here taking notes, so it'd be really great for Clara if she could know who all of you are. And we also have a visitor in the room. This is Lisa Hudson. She's the head of civil service. So I think it'd be great for her to hear a little bit about y'all too. So if you could, in addition to your name, just say a little bit about your work, so that Lisa and Clara can know a bit about you. And I'll start. I'm Ursula Price, and I do the community relations work with Lisa.
My name is Connie Washington. I'm on board with Safe Street Strong Community, one of the organizations that started wanted the IPA.
Matt Fraser, Chief of Staff for Councilmember Susan Gibby. Councilmember Gibby is the chair of the Criminal Justice Committee, and I staff her and anything.
That's right. Okay, Susan.
Committee work.
I'm Abby Rayco, and I am a social worker, one of the social workers here at the Public Defender's Office. So we provide counsel to folks in the Orleans Parish that cannot provide counsel for themselves. And as a social worker on staff, I sort of provide services that an attorney could not provide.
Cassie Pearson, I coordinate the legal clinic at Common Ground Relief out in the lower 9th Ward. Prior to moving here, I was a staff attorney for 10 years with legal services for prisoners and children in San Francisco.
I'm Ted Clark, Opportunity Center at Yale University.
I'm Susan Norwood with Community Mediation Services.
Mary Ellen Stitt with Kids Rethinking Wellness Schools. I work with their campaign to disorder justice. And Small Levine, I think police monitor out of the police monitor's office. Really happy to see everybody. Thank you for coming. And we will have forum because there are a bunch of people coming our way.
Did everyone get to see my agenda?
Yes. But should we pull up the table and pull up some more chairs? I wasn't sure how many people were going to be here, but I didn't want to make people feel on the outskirts. So I don't mind pulling this table up.
Sure.
And then circling some
Well,
chairs.
the two people that are that I know are definitely on their way are Mike Glasser and Simon Hargrove, and both of them like to appear off camera.
Okay.
So
Cool.
yeah.
All right.
So they can be over there.
You're safe. But Matt, if you want to come into the phone, just let me know.
Camera too.
I invited them to being.
There's plenty of extra chairs.
And I just wanted to also say a special thank you to Lisa Hudson, who's here at the meeting, who we're meeting with about civil service and mediation, because when we were talking about, in our group, when we were talking about inclusion and exclusion criteria, we had felt that we had hit a wall with some questions, and we needed the answers from anybody and everybody on whether there were any obstacles on certain inclusion and exclusion criteria coming in. And so why we put it together is because we've been working with Louisiana Public Health Institute, who has been kind enough to loan us 2 of their staff members to help us write a funding grants and look for funding grants that are relevant to mediation. As I had mentioned to Louisiana Public Health Institute, and really anybody who I talk to about funding, we do feel strongly that we do need to go with a final solution of public funding. So from a city agency or a state agency, possibly a federal agency. But in the meantime, we see as a possibility to actually apply for individual funding grants so that we can get the program started, and then we can get somebody into the position as coordinator, and they themselves can dedicate themselves full-time to raising their own budget and making sure that the office is permanent, because at this point, it's Ursula and I that are really doing the work, and we're trying to balance everything else in our office, and so a lot of the times we don't really have the time and energy that really is going to be necessary to raise this money. So that's one of the options, and what we did was we applied for a grant with a federal agency that is within the Department of Justice. We've sent them in a letter of interest, and that budget came in with a letter of interest, and then we've got to send them a formal proposal in a couple of months' time. So that's Louisiana Public Health Institute. They're still looking for other avenues, funding as well for us. As I mentioned before, on the 21st of March, we met with Civil Service, and so we met with Lisa Hudson and also with Jay Ginsberg, who's a hearing officer with Civil Service. And Lisa, fill in for me when my memory goes sour on this stuff. But a lot of the concerns that we had as a group, as far as including and excluding certain cases from mediation, Civil Service really didn't feel that it was their jurisdiction wasn't in their jurisdiction to really make a decision on some of these issues. And some of the issues that came up, which they said that they didn't have any jurisdiction on, was how a mediation would be reflected in an officer's file once a case has been mediated, even if the mediation is unsuccessful. So we haven't yet made a decision about what an unsuccessful mediation looks like, or if that's even a possibility, but Civil Service had said that they don't really have jurisdiction on that issue. If there's an increase in penalty as a result of a mediation session, so again, that's when you look at the administrative book for the police department, if an officer, for example, has had a complaint sustained against them for professionalism a year ago, and then they gain another complaint for professionalism, the punishment for that professionalism complaint, the second one, increases in the amount of time that the officer can potentially be suspended for. And so, in getting back to the question at hand, we asked if Civil Service had an opinion on whether there could be an increase in the penalty or a decrease in the penalty if mediation was actually used. And Civil Service had said that they don't have an opinion on it. Can mediation be refused for someone who has a significant disciplinary history? So what this relates back to is if an officer has had a certain number of complaints for a calendar period of 3 years, then they're referred to PEP, which is the school which officers go through in order to get additional instruction on how to act and to work as officers. And the question is whether an officer could be barred from a mediation if they had a certain number of complaints in a certain calendar period. We ourselves as a body hadn't decided what those complaints would be, whether that was even a possibility, but one of the issues we wanted to know was whether Civil Service had an opinion on it. We did not have an opinion on it. Another issue was...
Just to get a little background about that, so that everybody's on the same page. Civil Service gets involved after a disciplinary action has been taken against an employee. So up until that point, how the disciplinary action takes place, or why, or even, we really don't have much input into. And that's why we're saying that doesn't
probably would have a private opinion about it, but it's not
Right.
in the professional jurisdiction. So, confidentiality of pre and post surveys and the agreement. So what that specifically relates to is if we have an agreement between officer and civilian complainant over what the officer will do in the future, or what the what the civilian complainant will do in the future, whether those agreements are confidential. Also the level of confidentiality for the exit surveys. Exit surveys, we've explained before, relate to whether the civilian complainant is happy with the process, whether they feel the officer has actually understood his or her concerns. Same thing with the officer. We've yet to actually decide as a body what exit surveys we're going to be using or not, but the question that we pose to civil service is whether they have an opinion on whether those could be confidential or not. They felt that that was also not in their jurisdiction. And also, and this is an issue I'm going to touch upon later on down the road, is statements in a mediation, whether PIB can use those statements or not. So specifically, that relates to the confidential nature of what is being said in the mediation itself, and whether PIB, if there's an allegation of previous misconduct, whether PIB can actually use that allegation later on. And again, civil service did not feel it was in their jurisdiction to talk about that. Yeah.
You remember Jay having strong opinions about the confidentiality of mediation.
So, talk about that, because my notes might not reflect it.
Well, just that Jay, the hearing officer, felt strongly that traditionally mediations were confidential, and that they should remain so. But he didn't have an official opinion as a representative of the civil service, but as an attorney, he felt that.
Who is Jay, I'm sorry?
I'm sorry, Jay Ginsburg is one of the hearing officers.
Oh,
It's actually they're hearing probably officer right
So yeah, he certainly felt that.
Well, I guess it was a question as to whether the information would be admissible during a civil service hearing.
Okay.
Came up as well, and we think so, because generally they're
Yeah,
considered
and in fact, it's
confidential.
protected under the law. Mediations are confidential. You can't.
Although we are gonna have to talk about later, because let's say a person admits to a crime in mediation.
We're gonna be talking about that, because that's something that we've also been discussing with folks that are concerned. So, civil service, we also talked about what letter would make it into the civil service file, and civil service did not feel that a letter relating to mediation would end up in the officer's civil service file, but they felt it was up to the appointing authority to make a decision about whether a letter would go into the officer's personnel file or not. So again, they didn't feel that that was in their jurisdiction.
Actually, the employee can ask for it to be placed in their file, we would place it, but it wouldn't be anything that we would require.
And then Jay had mentioned whether an officer would be represented by counsel in a mediation or not. So that's something which I don't think that we've really explored as a body, but I think it's something that we should be talking about as well. And then we had a preliminary conversation about whether an officer could waive any of the time in the officer's Bill of Rights. So specifically, the PIB has a specific amount of time to investigate any complaint, civilian complaint, or complaint made by another officer against that officer. They have a certain amount of time that they have to investigate that complaint. And the question really came up, and this has come up with us also as a body, whether we could have a mediation and have that eat up a portion of the time which PIB would need to investigate the complaint. The officer Bill of Rights demands a certain amount of time that the complaint be investigated by PIB. If the complaint is not investigated in that time period, then the complaint is dismissed. And that's according to state law, and so that's not anything that can be changed by city law. And so the question is whether an officer could actually waive portion of the time or could waive the Bill of Rights if it actually related to mediation or not. And so that was just a discussion we had had. We didn't really come to any conclusions. But the next meeting we had, actually right after we had the meeting with Civil Service, we had with our counsel and the Inspector General, who's quite knowledgeable on Bill of Rights and these legal issues as well. And so that was the next thing that I was going to talk about. Specifically, our counsel for the Inspector General's office raised a proposal, which is the first proposal that we've heard about the officer's Bill of Rights and the statutory time period that an officer has to be investigated for a complaint. And specifically, the proposal was, and she just offered this as sort of a creative solution to the problem that we were seeing, was that there's two different tracks. And there's one track which relates to complaints, where the complaint would have to be investigated for a specific period of time, and then the complaint would be dismissed if it wasn't investigated in that time period. That's the traditional track, which again, that's according to state law, and it's a hard and set requirement, and nobody's proposing that we go to Baton Rouge to actually change that, but that there be a secondary track which did not relate to complaints at all, and it specifically was considered to be a mediation track. And that if the complainant and the officer agreed to a case being mediated, that it was no longer a complaint, and it would just be considered a mediation itself. And then it would, because it's not considered a complaint, it would no longer, legally speaking, be bound by the Officer Bill of Rights when it comes to the timing that it would have to be investigated under. And so that was one of the proposals that came out in the meeting that we had. Do you want to, I'm doing a report back now for the meetings that I've had over the last month and a half, but I'm going to leave it up to Ursula if we want to discuss that in detail later on, and when later on when we want to discuss that.
Yeah, I'm thinking about it because it seems so complicated as it is. Our discussion today is all about the process of mediation, right? So I think it's appropriate to talk about it.
Okay.
Um,
So let's table it then until I finish the report back. So the other issues that we talked about, and again, we just talked about legal issues with our counsel for the Inspector General, and also the police monitor. We were talking about public records requests and whether any of the material that, written material that was being, that was created as a result of the mediation, whether that would be, could it be subject to public records requests? And the answer that we received back was yes, that it would be. And so what we're looking at is we're looking at the exit surveys being, this is the paperwork that we had anticipated at this point. We can, there might possibly be other paperwork which we haven't anticipated at this point. But the exit surveys, so whether the officer or the civilian complainant is satisfied with the process, and then also any agreement that the officer and the civilian complainant would have. If the mediation coordinator and the mediation office is placed within the city, then that paperwork would actually be subject to public records requests. The other option is to actually place the office in a nonprofit. We've approached some nonprofits and spoken to them. We had a very superficial conversation with Vera about whether we could place the office with Vera. If that is the case, it was our counsel's opinion that it would not be subject to public records request because it would no longer be considered a city agency. However, regardless of whether it's placed in a nonprofit or it's placed in the police monitor's office, that paperwork would still be subject to subpoenas. And so a subpoena could actually be issued either by judge or initially by an attorney and later on agreed to by a judge, in which that information would be subpoenable.
That would just be the exit survey and the agreement.
At this point, that's all the paperwork we've discussed. We don't really anticipate any other paperwork really coming out from this process, but the understanding would be that the the paperwork, any paperwork which the program actually produced would be subject to a subpoena. If this stuff isn't clear, also make sure to just let me know. So, and then, we had also been talking a little bit about the confidential nature of the information that is in the mediation itself. And our counsel had mentioned the fact that officers and also civilian complainants can sign a waiver saying that they would not share any of the information, but that it would still be subject to subpoena. The waiver that they sign doesn't really have any, it doesn't place a legal obstruction in front of a subpoena. And this was an issue actually we had talked to civil service about as well as with our counsel, the question of waiving their appeal. Both bodies really didn't understand what appeal could be had from mediation. And so, both our counsel as well as civil service didn't really think that an appeal would really be an option with a mediation. And we ourselves, Ursula and I, when we were speaking to civil service as well as with our counsel, couldn't really think of an issue where an appeal would come up either from a mediation. Just because mediation is going to be is so different from the traditional path of the complaint investigation. And then the last thing that we spoke to with our counsel was the possibility of some of the statements inside the mediation, even though both parties would agree that it was confidential, what would happen if those parties had spoken to, decided, let's say, for example, the civilian complainant wasn't happy with the end result of the mediation, or they thought they were happy with the end result of the mediation, and then afterwards they decided they weren't happy with it. Could they then go out to PIB and divulge some of the conversation that had occurred inside the mediation? And one of the things our counsel had mentioned was that PIB can decide in this process to not allow that to happen. So when it doesn't involve, for example, a criminal offense, when it just involves a possible administrative offense, PIB can say, we're not going to allow you to use any statement that the officer makes in these mediations against the officer later on, and PIB can make that
I
decision.
have a question. I'm a little confused listening to some of the report, because I think that if you start with the premise that the mediation is confidential, then whatever anybody else has to say about the information, if one of the parties or anybody external to the mediation becomes irrelevant, because confidential means that information, unless it's discoverable by some other means that it can't be used against either of the parties.
Right.
So
So the
it would
question is
be
who would
a
actually
moot
agree
point.
to that? And it's almost an additional protection for the officers to know that PIB would agree that that was confidential, that they couldn't use it.
A question on, when you say agree, are you talking about on a case-by-case basis, or you mean up front?
Up front.
Well, then
Okay.
they would agree that it was a mediation as opposed to
Right.
another kind of hearing.
That's correct. I mean, once they say it's a mediation, that's it. The officer, the civilian, anything they say within that context, unless something criminal comes out of it, which is a different issue.
Right, that's an
We haven't really
exception.
talked about how we would deal with that yet, but
Which we're gonna
it's
talk
just
about
an
later.
administrative issue. The person's not happy with the process, whatever. It's a dead
Yeah,
complaint, more or less, at that point. There's nowhere for them to take that complaint related to PIB, because this was a complaint that was said to be a mediated, potential complaint. Both parties agreed, it's mediated. The fact that one party may choose they're unhappy at some point, that's just unfortunate.
They can go talk to
That's all
anybody they want, but they cannot have any effect from the talk. I mean, they can certainly make people mad by talking about confidential.
And the only question that we had is what happens because we were trying to think of different contingencies and different possibilities. What would happen if everyone had agreed that it was confidential, and then one party decided that they would break the confidentiality. Do we need an extra check from PIB up front saying that if this was a non-criminal issue, deal with criminal issues later on, if this was a non-criminal issue that came up in the mediation, that PIB would be allowed to use that?
But see, that's where I'm confused, because PIB would not, nor any court, nor anyone else would not have the, I don't want to say the right, maybe, but there would be no reason for PIB to assume they did have any reason to go forward with the, if somebody came and said, changed my mind, I want to tell you this.
And if we feel secure enough that PIB would take that opinion in this process, then that would be the decision of the body. If we felt that there's a concern of ours that PIB in
That they
some
would not
exceptional
respect
circumstances would not respect the confidential nature of the mediation, then the question is whether we need PIB to actually say up front they're not going to use any statement that's
I
being
mean, I would think
I think
you'd
we
have to
need
have
that,
PIB.
I mean, I don't think we need to wait for that until we at that point, but whenever we're at the point that we need to be positive about their position on that, we just need to ask them for a formal position.
Endorse the mediation program, or else don't do it. I mean, why do it if there are gonna be holes in it? Especially, down the road.
I think that undermines the entire premise that we're working under
Right.
right from the beginning. And on the subject of criminal issues, we also have to be, I don't want to be construed, because in many cases, even administrative violations can be twisted into a malfeasance, which makes it criminal.
I think that's
And
a
we
much
sometimes
bigger
do
issue.
that, PIB sometimes does that in order to get around the 60 days, and they'll open up an investigation on, say, malfeasance or something in that fashion, to have a criminal investigation so that the 60-day rule does not kick in. And then at some point down the road, when they decide not to pursue it criminally, then they open up the administrative investigation, the 60-day window begins to turn. So I think it's kind of important that we get that established up front, right from the very beginning, and the PIB has to agree to it. We don't want to litigate it later.
Right, okay. So then, do you want to table this later on to have a final decision on whether PIB would have to sign on to the fact as a separate statement that it would be confidential? Or do we want to have that discussion now?
Okay, just so I'm clear, you're talking about PIB requesting information about the mediation from whatever agency is running.
No, if a party would
If a
go
party
to
came
parties.
to PIB and actually said, look, I know I'm not supposed to be telling you this, but in fact, this officer had said X, Y, and Z, and so I just want you to know about this, so it will, and it might potentially start a new investigatory process. And that was the question that we had raised with our council, what would happen at that point? Everybody's agreed that it's confidential, however, do we need another check on the system? Do we need PIB to actually sign on that they wouldn't be able to use that statement? And if we have confidence that PIB says everything's confidential, and we don't need them to actually say that, that they're not gonna use any statements, then that's the answer to the question.
Well, it sounds like we don't have confidence.
I'm a lawyer, so I'm
No, I
always
don't mean
thinking
you.
about
No,
possible
but it sounds like
contingencies.
one should not have confidence given the report that you've given. I mean, if there's an
This report is
expectation.
not coming from PIB, this report was coming to us, speaking to our council over all the possible contingencies. And so, I'll just say that I'm a very skeptical lawyer, and I always try to make sure that every base is really covered. And so that's the reason why we were spinning questions at the attorney, because I didn't want to come back to our group and not have some answers to these questions.
Okay. Just my own clarification. People commit to mediation, they're in the middle of that mediation process, and they realize this really isn't what I intended to commit to, I want out.
Yeah, that's a different question.
Well,
which we'll
but
explore
it's
down
still
the road.
confidential,
That's
it's
the-
happening
yeah.
while it's
Right.
going on.
So that has to, the person can't just say, oh, this isn't working
But we're not, I just wanna clarify, we're not talking about the larger issue of what happens if somebody is unsatisfied with the mediation itself, because that's a bigger issue that we've yet to really decide. We're just talking about the confidential nature of what's gone on in this process. And one certainly relates to the other, but we're just talking about that level of confidence and whether somebody could then go later on to PIB and say, this issue came up, I want to start a new investigation about it.
Will the complainant waive their rights to go to the PID? Is that part of the process?
We can make that into a possibility. We can certainly have folks waive their rights up front, and that's been something that we have discussed as a proposal.
Well, generally, don't they go to PIB to begin with? That's where it stems from, it started.
Not necessarily.
I know
You
we go
we have,
through your
that-
office.
that's a decision that we've got to talk about later on today as well. Who makes that decision?
Well, okay, I think we're overcomplicating this a little bit though. Right, because the issue is how we define confidentiality. We agreed on the first day that this was gonna be a confidential process, right? So we can drill down when we talk about officer incentives, about what the exact nature of confidentiality is. But I would also flag in the sample confidentiality agreements that we've seen, that people did in fact waive the right to go back and make a complaint just because they didn't like the mediation. So I suggest that,
You did tell.
I suggest that we, because that's in step 5 of the mediation process, right? Today we need to finish steps 1 through 3. I suggest that we take up the exact nature of confidentiality in our next meeting when we get to that step. Does that make sense to people?
Are people okay with that? Yeah. Okay.
And I'm gonna make specific notes about these questions that we're having.
And we also have Lauren who's taking good notes, so. Okay, so that was the end of our discussion with our council. And we also had a conversation with a partner over at a large law firm here in town named Lisco and Lewis, I think it is. And we had specifically talked to him because a member of our planning committee, Michael Cowan, had connected us with them to see if they could help us with providing mediators for the program, voluntary mediators, so mediators that would be working free for the program. So we sat down with him and we talked to him about a couple of issues, and we have, what we had told him is that we haven't made a final decision here in the group, but that what we were thinking about is, we certainly thought that we needed to use voluntary mediators, and that we should, that we were considering using mediators from a variety of backgrounds. And so that was the reason why Michael Cowan had connected us to him. We had found out in the meeting, Ursula and I, that likely Lisco did not have any attorneys that were trained mediators in the firm, but that he would be willing to have his attorneys be trained, and possibly also to fund the training bill for his attorneys to be trained as mediators, and that they would work with our program. So we're speaking to him about that process as well. We certainly haven't made any final decisions at all. We're sort of still exploring issues, but a couple of issues had come up when it came to that conversation. And one of the questions that had come up is what kind of training what kind of training individuals would need to become mediators. So that's distinct from the training that they would need in order to know how to do mediations that are specifically police complaint mediations. So how much training they would need in order to do that, and I did some research on that topic, and feel free to fill in as well, Susan and Lou, where I drop off, but I talked to a couple of training programs that work here in Louisiana, and they had said that in order to be on the court-appointed list, that individuals normally need about 40 hours of mediation training words, they could be on the court-appointed list. However, there isn't any set mandatory time period that individuals needed in order to be trained to do mediations. So what that means specifically is that if I had a mediation because I had a problem with Ursula Price in my work relationship, I could ask Lou to be my mediator, and Lou wouldn't need any hours of experience. I could just take him in as a mediator. However, for the state of Louisiana, as is similar with other states across the country, if you want to be on a court-appointed list, and so that's with the court-approved programs that actually do mediation, then you need to have 40 hours. And there are different standards. For example, if you want to be a juvenile, if you want to mediate juvenile court issues, then there's a different standard for them as well, and I can provide that to folks at a later meeting, but that was something that I found out in conjunction. Another issue that this partner at LISCO had mentioned was security, and that's not an issue which we've talked about yet before, specifically security inside the mediation venue itself, and whether we would need a venue where an individual would have to go through a metal detector, so as to detect whether they were carrying any, whether they were armed, and whether there was any other security precautions that would be needed before the individual went into the mediation. And what I did was I called the programs across the country to try to figure out what other cities have done. And what I found is that no city has reported to me that they had any problems with security whatsoever, and that no program has complainants go through a metal detector. However, there are 2 programs which have receptionists which actually greet the complainant beforehand, and in 2 out of 2 occasions, the person that's meeting the individual is a security guard, but they are an unarmed security guard. And so they're just the people that normally are sitting at the bottom of every building entrance. And so it's not special for the mediation process itself. It's just when the individual comes in, there's a security guard that's actually there. So, and then the other 2 programs, that was DC, but that's the case, and also New York City. Both, much larger cities than ours that have traditionally much different security problems than ours, and than we do here in New Orleans. The other programs, San Francisco, that I've tried to reach out to, and also Seattle, I have not heard from them. I have not heard back from them on security issues. And then the 5th program that I got in contact with was Kansas City, and they don't have anybody that actually greets the complainant except for the mediation coordinator himself or herself. And they are not armed, and they're not a security officer, and they themselves also have not ever had any problem. So that's my report back from LISCO. I think that we need to have a different conversation about whether we want a law firm to be volunteering attorneys for this process or not, and whether we want, if that is the case, if we do want a law firm to actually be volunteering pro bono lawyers, whether there'll be who is going to be doing the mediations themselves. Is it just going to be attorneys, or is it going to be attorneys and other community trained organizers? And if it is going to be the latter, where we're going to be getting those resources. And then lastly, believe it or not, one of the bigger meetings that we had is the mediation planning board got together, and so that's Chief Surpass and Susan Hudson, the police monitor, and retired Judge Calvin Johnson. And so that board got together, and they spoke about some of the principles, the preliminary principles that we had agreed to here in this meeting. And the purpose of the mediation board is basically to approve or to reject the decisions which this group themselves have made. And so they went through some of the preliminary decisions. They did not make it through many of them, frankly, because it was their first meeting, and so there's sort of a lot larger of a discussion. So the first decision that was agreed to by that mediation planning board was whether there would be other people that would be allowed in their meeting, so if a staff member of each member would be allowed into that meeting. The reason why this issue came up was because when I first walked in the meeting, Chief Surpass was in the room, Susan Hudson was in the room, Calvin Johnson was in the room, and Deputy Chief Westbrook was in the room. And the blueprint did not state one way or another whether any other staff members would be allowed in. And so what I did was I invited Chief Westbrook to step out of the room, and the three-member board made a decision about whether to allow each one of the board members to have a separate staff member. The board said yes, that was fine. Chief Westbrook came back into the meeting, but it was also agreed by the board that that there would only be 3 votes, 1 vote per member of the board, so Chief Westbrook would not have a vote. And in the future, Calvin Johnson could have an employee to be with them, and Susan Hudson is most likely gonna have Ursula with them in the meeting. So the second decision they made was that all their decisions were gonna be made by consensus. So it's not gonna be by majority. That would mean that the chief and Susan Hudson and Calvin Johnson all have to agree on make that decision by complete agreement by consensus.
So, did that say what would happen when they couldn't agree?
I know. We haven't got into that. We did get to a point where they couldn't agree, and I said I would do some more research. But it's certainly something that we're doing right now.
Work for me.
So the other thing is that they agreed to the project structure. So the project structure is us as a planning committee, and then them as the board and what they do, and what we do as a project committee, and it also includes myself as chair. So I'm chair for the board, and I assume I attempt to have a completely neutral role. I cut off my opinion in several places. I self-censored myself in a bunch of places, and just did sort of what I did was it's my responsibility to actually tell the planning board what happens here at the planning committee, and to inform them of the decisions and why the decisions were made here at the board. Okay, and so another issue that came up was whether mediation needs to be voluntary, and largely the board felt that it should be voluntary, and specifically NOPD felt very strongly that it needs to be voluntary because when PIV, for example, have done informal mediations between complainant and officer, the only reason why the officer really is going through that mediation is because Deputy Chief Westbrook has asked them to do it, and that that would not be oftentimes a process which the officer himself or herself would agree to unless the chief had initially proposed it. Then this issue of confidentiality came up, and again, what I want to just emphasize is these principles that they're going through were the initial principles that we decided on, and we decided as a body that we could revisit these principles if we felt that something down the road contradicted with our agreement to these principles, and the planning board said the same thing, so that they were agreeing to things initially, but they could revisit it. The issue of confidentiality came up. Everyone felt very strongly that mediations needed to be confidential. However, the issue of what would happen if something criminal actually occurred in the mediation, that was specifically raised by the NOPD. And when I refer to something being criminal, specifically the issue that was mentioned is what happens if there's a threat to somebody's safety inside the mediation. And the example that they had given was not a threat, like a physical threat to somebody's safety, but a verbal threat to somebody's safety, and how serious it would have to be in order for it to then become something that was a criminal issue, and then what would happen to the confidential nature of this process. And so what the,
Some rules up front that deal with that.
what?
And
Do
that's
some
pretty
rules straight up
standard,
front
that's
that
very
deal with
standard
that.
in a mediation, that any threat to anybody's
Well, so what I did was, since that was tabled based on the criminal issue coming up, I said that I would go ahead and do more research. And so what I did was I spoke to all the programs that I'm normally speaking to across the country about this issue, and each one of them said that this has never come up for their mediation program. There hasn't ever been anything that's been criminal in nature that's come up. However, and none of the programs actually make any special waiver of the confidentiality for any criminal issue. However, DC had told me that they had heard that other programs, which are not necessarily police complaint mediation programs, but other mediation programs, had come up with a waiver where when the officer and the complainant actually says this is completely confidential, there's an exception made when there's a criminal situation that had come up. So that's something that I learned in speaking to other programs, but again, no program that was a police complaint mediation program actually had that exception in their waiver before. And no police complaint mediation program has ever dealt with that issue. What some police complaint mediation programs had said was that there are people that make threats, but the question is whether it's an empty threat or not. You know, like, and they didn't give me an example, but I think that that's something that we can talk about later on.
Well, I would think that anything that's discussed related to past events would be confidential. Anything that would be new, like an instant threat, would not be confidential. That thing would have to be addressed right then and there, and I don't think that would be covered. I wouldn't expect it to be covered, whether it be the officer or a civilian. I wouldn't think that would be covered under confidentiality if it's an instant threat for that moment. I don't think you have complete and utter confidentiality for anything that you can say or do. I think it's just relative to the thing we're talking about, past events. But if you're gonna threaten somebody across the table, I think that has to be addressed right then and there. And it's probably not gonna come up, but it's probably something we could address up front, get it out of the way, and write it in. And the likelihood of it being something that's probably remote at best, but it wouldn't hurt to do it. That would be my opinion.
And just sort of following up on what the captain had said, what the mediation programs had said to me was that they really leave that issue up to the mediator himself or herself to determine whether this was actually a serious threat or not, and whether it was something that actually warranted a report back.
I think a lot of what we're saying is kind of messing with my head about what mediation is, because
Yeah.
the mediator doesn't decide whether I feel threatened. Point blank. So that's gonna be the end of that right there, and that should just mean all the rules are gone now, because we had a rule up front, there's not gonna be no threats, no mess like that, and once it happens, then all the other rules are gone. So I don't know, we need to think about that. The other thing was that, as I'm understanding what we're saying, and you know, sometimes I'm slow, but this is what I'm feeling like. When a person decides that they're gonna do mediation, we're saying that's one of the choices instead of something else, like going to PID or this other thing. So once they decide that, they are agreeing, if I'm hearing this correctly, that if that mediation works or doesn't work, that's as far as they can go. In other words, if they have a mediation and neither side agrees, this is gonna waste of time, you're a jerk, next case mediator, that's it. So the report just comes down, mediation failed, but there's still confidentiality and they still have no right to go anyplace else. And they have no appeal.
Oh, I don't know
Well,
about that.
I'm not, we haven't made
We
that
haven't
decision.
made
They
that
go
decision
someplace
yet.
else, but they still have.
That's the question, because if you have a mediation, first of all, mediation, like when the question of appeal, a mediation is not an arbitration. The two people decide whether it's been decided. So what's there to appeal to if we've decided? And if we find that we cannot decide, then the mediation just didn't work. So now that the mediation didn't work, and we went through this mediation, and the mediation was an alternative to something else,
Right.
and it doesn't work, does that mean that, well, you chose mediation, that's the end of it, whether it worked or not?
You still have another choice. I mean, it's like if you go to mediation from a civil matter and it doesn't work, you can still go to court.
So
So
then the confidentiality to, up until that point in the mediation,
That
it
cannot.
still not be used in
Cannot
the
use
other
that, correct.
proceedings,
Right.
but you can say, here's my testimony.
But we haven't made a formal decision about that.
I
because
just want to
that's a
flag
tricky issue.
process-wise that decision
Yeah.
is being made under step
Someplace else.
5, which
Just
should
check.
be our next
Next
meeting.
meeting.
Right.
Yeah, and I'm wondering, whether, I mean, this is information that's important, but isn't this kind of out of sequence when we're supposed to be talking about?
Well, what it is it's a report back on the initial principles, and in so far, I didn't tell the board who said what, because in this group, but I did inform them of the initial conversations that we've had, so that they're informed, and they get into the process of thinking. And this board, what this planning board decided is, they decided the initial, principles. And so, what I'm going through is the initial principles, which the board either signed on or not, and I'm also talking to this group about what their conversation was. So,
And I'll be honest, if I had it to do over again, I would not have given them the principles as the first thing for them to look at. Right, because we haven't made all the decisions that finalize the principles ourselves, right? We adopted them in the beginning in a vacuum.
But what is your goal in giving this report? What are we supposed to do?
to inform you,
Just listen?
yeah, to
Okay,
inform
so
you.
our
they're
questions and
raising
so on are
issues
really
that-
not relevant at this point.
We're gonna hold all the questions they raised so that we can consider them in our
Yeah,
future
okay.
discussions.
All right, so we just listen.
I just want to make a quick comment regarding to the verbal threats and that type of thing. And sorry, social worker speaking, so this is just sort of how I operate. I number one go into situations understanding that everybody has different understandings of like what mediation looks like, whether that be because of their background or anything like that. And two, I know that we brought up at the last meeting mediation with people with mental health issues, but I think that that will come up. I have clients that have schizophrenia or other things that come in and just curse or whatever, call me B, all these things. And I'm not going to take it in a personal way because I understand that their brain is operating a bit differently than mine. And I think that when we think about mediation and verbal threats and all these things, we have to consider who is going to be in that space and sort of what's going on in their brain compared to what's going on in other people's brains. And so they may say things that seemingly feel like really harsh or threatening, but at the end of the day, they're walking down the street saying that. So, do you know what I'm saying? I just want to throw that out there as things that we consider to think about if we think about like penalties or anything like that for verbal threats and all those things in a mediation.
You know, we haven't gotten to that point where we're establishing ground rules
Yeah.
before we open up the mediation. That's what it sounds like.
Yeah, we
We'll get
still
there.
have to decide
Yeah.
all of
Yeah.
that.
Although that should come right after we do suitability criteria. That step 4, provide information to parties, I believe that's where we decide whether or not officers can be represented by counsel, what are the ground rules for mediation, et cetera.
So they had, on the principle of whether we would be offering bilingual mediators or translators, everyone agreed to that principle. Ensure mediation is for issues that meet the inclusion criteria, everyone was agreed on that issue in the board. Ensure mediation does not replace police accountability, everyone was agreed on that issue. Clearly explain the mediation outcome, and this is from the blueprint that we all as a body agreed to. Provide, clearly explain the mediation outcome, everyone on the board was okay with this. Provide officer incentives to participate in the mediation. The group felt particularly strong about this issue. The group thought that there needs to be a true incentive for officers, and for example, if failure to participate in a mediation is sanctioned or punished, that means that the mediation is no longer voluntary. Deliver the program with trained mediators. The group tabled this until they understood what the national and the local standards were, and that was, again, what I was reporting back to them when I did the research on. But they certainly wanted trained mediators, but they didn't know what trained actually would mean. So recognize the power differential. Again, this is a general concept. This relates to whether officers are allowed to have their guns and their uniforms, whether the power differential can be recognized in a different way other than asking officers to not come in with their uniforms and their guns. Also, the board agreed that the power differential needed to be recognized. Record the success of mediation. certainly decided that exit surveys were essential to this process, and so that was agreed to across the board. There was a disagreement, and again, this is an issue which I told them, the same thing that, I'm telling everyone here, is we're gonna be making that decision down the road. There was a disagreement over what a successful mediation was. And so, Chief Westbrook and the chief, and Chief Surpass felt strongly that there needed to be some kind of piece of paper to record the success of mediation, that they needed some kind of paper in order to say, okay, we now no longer have a complaint, a viable complaint any longer, this process has been closed. And Judge Johnson felt strongly that a successful mediation is two people simply meeting together and actually sharing their viewpoint, and that piece of paper is not necessary in order to reflect that success. And what I told them was I was gonna go out and I was gonna do research with other programs to see what other programs did in that regard. And interestingly enough, what I found across the board with other programs is that they tried their best to have a piece of paper, which was an agreement, and the agreement is, a lot of the time simply, I've listened to what this officer has said, this officer has listened to what I've said, and that's our agreement. But in some occasions, they can't get a sign off on that agreement, and that's okay for their process, for their program, to not have that piece of paper, but they strive to actually have that piece of paper. So that was it, that's how far we got with the board. The board is actually meeting later on this week, I think on Thursday, in the afternoon. An issue will be, if everybody hasn't noticed, I'm 6.5 months pregnant. So an issue will be who's gonna be the neutral chair in that process, and we think it'll probably be Ursula, but if people have other suggestions on who else could be a neutral chair that's sort of written into the blueprint, then please let us know. That's where we are. That's my report back. Sorry it was contentious and long-winded, but.
And I will make sure that these notes are posted up there too, so that you can actually see them at a certain point. Okay, so it's 10 after 3, or 3:07, right? So we have a little less than an hour and a half. How are people feeling? Do y'all need a break? Do you need to stretch? Can we barrel forward? So,
Thanks, Lisa, for coming.
Thank you.
last week we embarked upon exclusion criteria and tabled some of them pending information from civil service and things like that. I'd like to back up a little bit though. So, this whole discussion is about the process of mediation. And step 1 in mediation initially says that the citizen makes a written complaint of alleged officer misconduct to IPM or PIB or a community organization. So I think this is the point where we need to decide, all right, first of all, what is that intake process look like? The proposal that we got from General Counsel in order to avoid the 60-day time limit on investigations is that when the person comes in the door and they tell an intake person their story, the intake person says, okay, you have 2 options. You can lodge this as a complaint, or you can lodge this as a potential mediation, or potential issue for mediation, right? And that way, because the police officer bill of right defines, basically says once the person has made the complaint, the clock starts, right? So we have to call it something other than a complaint for that clock not to start. One caveat with that though is, if that person is coming in and they cannot name the officer, right? Because in some small investigative steps would have to be taken to determine who that officer is, and once those steps are taken, I believe the clock starts.
Well, they have a few days to determine exactly what they have before the official 60 days start. But one of the things you just said, I raised a question on. If they report to PIB of some possible